we hate the regulators in West Virginia, we hate the law in West Virginia, we think it's the worst in the world, but then we go to Kentucky and we realize, oh my God, thank God we don't live in Kentucky, all right? So, because nobody wins in Kentucky. I think it's illegal. But the sulfides are important because it used to be 100, the sulfide level of 100 was indicative of mining impact. Now, the West Virginia DEP has guidance that says 50 is, and I'm not sure if it's parts per million or parts per billion. I guess it would be parts per billion in sulfides or million. I don't know. Like one or the other two. 50. There's new guidance from the West Virginia DEP that says that 50 is indicative of mining impact. And in a recent trial, all the experts got in a fight, and we actually got the defense defense guys to agree that the background level using the groundwater inventories in the permit were between 10 and 12. And our expert then said anything over 25 would be twice background and therefore indicative of mining impact, especially over that short period of time. And so I say 25, 50, 100. The sulfide monitor we had, just in the 2 days, we were anywhere from 3 miles to 1,000 feet. Probably less than that. Probably 3 miles to a few hundred feet from long wall operations underneath. And none of the houses we tested was below 115. So now we haven't got the old groundwater monitoring. So it's a James Justice, and I guess you guys have a lot of dealings with old Justice mines here. So anyway, that was just to answer your question that you had talked about earlier.
It's a parameter we're definitely interested in. I think it's one of the main ones we need to be looking at with these fracking wells. It's one I know they're monitoring pretty extensively.
I just lost a huge fracking case this week, as a matter of fact. I just lost one.
That actually seems like a good illusion to go ahead into Kevin's qualifications and our background and purpose for being here. Do you want to go ahead and start up?
Should I just list all the cases we've lost? Okay. Actually, I'd like to do a CLE someday on the ones I've lost. Because I think I got ripped off in every single one of them. Especially the fracking case I just lost in the Fourth Circuit. Yeah. We
can get into the bitterness of defeat at the end. But so we get through some of the productive parts at the beginning. My name is Nick Getzen. I'm a current 2L over at Lewis and Clark Law School. And I used to work for this gentleman, Kevin Thompson. And the reason I organized this panel today was because in previous years at APIEL, I had seen incredible public interest attorneys doing all sorts of amazing work, amazing activists, and then also community leaders, and then also attorneys doing direct action support. In no year that I've been here have I seen a workshop or any real discussion for folks that do environmental torts. And it seems to be something that a lot of public interest attorneys don't necessarily look towards. So, as much as we can within an hour, Kevin and I were going to go ahead and break down some basic tips for an attorney that's looking to start bringing in some environmental torts into their practice and what they want to do. Some of the reasons why that can impact things at a larger scale, and then also how to do that type of work in a way that actually increases the amount of participation, organizing, and activity from the clients at a legislative level, so that you're empowering folks and not disempowering them, which can be a problem sometimes within tort litigation. So with that said,
F5.
F5?
F5. Right, there you go.
So, we're here because we want you guys, every single one of you, whether you're attorneys or whether you're in high school, to eventually start doing environmental tort litigation. And actually, just by show of hands, can I see who here is a law school student or a current lawyer? Just so I know who we're talking to. Okay, so most of us, but not everyone. No, so I guess we should say, do you want to say what a tort is, just in general?
Well, any civil wrong not in contract. But I think that's what I remember. But I mean, basically, it's all the things you sue somebody for money damages. Yeah, like you get, like somebody, like I guess it's kind of out of favor now, but a lot of them were battery cases where somebody get hit and they sue somebody for damages.
Yeah, if somebody's hurt you and you have a legal remedy to go ahead and seek some kind of recourse from that person.
Right. And you can get injunctive relief in torts. And as I was discussing earlier, my very first lawsuit against a coal company, I'd never heard of smacker or skimra. That's like the baby smacker in West Virginia, and I brought it under. I mean, it was a coal mine, and they had buried a bunch of fueling and giant vehicle maintenance waste. And I had all kinds of RECRA chemicals in there, and I'm like, gosh. I remember my environmental law class, this is a CERCLA violation. And we had a baby CERCLA called the Hazardous Waste Management Act. At that point, the judge had never had a case like that either. He didn't know any different. The defense lawyer was pulling his hair out because we didn't know what we were doing, me or the judge. And I was on the wrong statute, and I got all the way to trial, and I had a tort claim, and I won the case. I got a verdict, I collected, and I had the wrong statute the whole time. But the way that I survived in that case is eventually, I mean, you know, I recovered on a negligence theory. So who cares if I had the wrong tort? I think had that case gone to the appellate level, I think I would have had a real problem collecting fees. I would have had a real problem demonstrating any kind of expertise, since I had the wrong law written down in the complaint and then litigated under the under the wrong law for 2 years, and then won the case under the wrong law. And the defense lawyer made an excellent record as to why I had the wrong law, and the judges blew it. And the judge is the same one you see in the paper today, who just got arrested, indicted for having an affair with his secretary and trying to put her husband in jail. It's Thornsberry. It's a big thing in the paper these days. But that was actually before he kind of broke bad. He broke bad in like spring of '08, so this was like fall of '03. He was still a good judge and trying to do the right thing. And he just thought, this big defense lawyer was giving a bunch of gobbledygook with these other statutes, and I made a good argument. So that's a great thing about tort, because I would have survived on the damages because I had all these tort claims, nuisance, trespass, all that. I would have gotten eaten alive on my fee application because I had no standing to bring a Hazardous Waste Management Act claim against a coal mine. Congress was out of its way to make a special law for me, and I just didn't understand it.
And we'll actually have another example later where Kevin alleged a tort that didn't exist at that point. I realized that didn't exist and accidentally created a new tort because of it. But and I should say, I meant to introduce. So with all of his humility, Kevin brings a lot of experience doing these types of torts in West Virginia, having spent much of his past decade in Mingo County, one of the most corrupt and ridiculous places. It's been run by coal completely for forever. But Kevin is, he also has been a finalist in the Final Four for the Trial Lawyer of the Year the past 2 years running. One for his work in one for the resolution of the biggest toxic tort ever against the coal company, and the running of water lines, the achievement of getting water lines run out to a community of the folks out there that had water that was impacted horribly by slurry. And this past year, for his work in creating the new tort of grave desecration in West Virginia after a natural gas company bulldozed an African American graveyard, thinking they could get away with it. So, reasons to do tort litigation, just a couple real quick. Obviously the first one is to win individual justice for the person that you're representing. A lot of times, I think tort attorneys or plaintiffs' attorneys in general can be unfairly characterized because people see them as working to recover money, which is part of what you can recover. And it's something that you have to always be kind of fighting against in terms of your reputation out there in the community, because it is a lot of what you do. But if you have a client who is, say, flooded off of a mountaintop removal site, and their home is completely destroyed, obviously what they need is they need money. They need money to go ahead and get a new house. And so that is a big part of what you can recover. The other thing, and something that some tort attorneys don't focus on near as much as I think Kevin does, are all the different options as far as injunctive relief. And that's one way you can really fight against any kind of impression that you might be some greedy plaintiff's attorney. Because really, you're always leading with injunctive relief if it's possible in a claim. So if you've got water that's horribly impacted, the goal is to get water lines run out to that community or to get replacement water. You're also going to sue for money damages for those people. If you've got a flooded site, you want to get that site replanted and regraded so that people aren't as likely to flood next time. And there are all sorts of injunctive relief options that a lot of attorneys don't really spend as much time on, but they help give you the moral standing and the standing within the community to really do this type of work effectively, I think. Another reason, through torts, in addition to helping out individuals, you can change the baseline for the economic reality for corporate behavior. So every time, as an example with flood cases, it's just pretty standard that if a coal company is in an area where people live and they engage in mountaintop removal, they're going to increase the chance significantly that people flood below them. That's their standard operating procedure. The only thing that holds them accountable to a better standard of practice, or not the only thing, but one of the things, is that there's somebody actually out there tagging them every time they do it. So that, every time they flood someone, they have to actually pay for the damages they've caused.
The DEP had they made all of the, I think it was the superintendents in West Virginia and the mining engineer come to a mandatory training class just this spring, where they said, okay, you need to redo the way you do your SWORAs, your stormwater runoff assessments. You have to use actual site numbers, not pull things out of the air. And they said, and like one of our experts was there, and they said, if you don't follow what we're telling you to do today, you're going to just get sued time and time again. And then Buffalo, or Consolidated Coal, actually withdrew a permit that we had a surface mine board claim on because they had used the wrong NCRS, the National Soil Conservation Service, soil classification numbers for a site. And then when we started looking at other sites, every single mountaintop removal permit in West Virginia uses the wrong soil classification. So, all of these suits that have started piling up in the last few years, the DEP selling point was, do this or you'll get sued.
And one thing that's nice is in terms of having an overall impact and making the coal company or the gas company or the oil company pay, is that to some extent, you make them pay that as soon as you file that complaint. Even if you lose, you're making them engage in costs that they wouldn't otherwise have. So you're actually shaping that economic picture regardless, as soon as you begin that litigation. And the last thing, we'll get into it more, but is using litigation, both successful and unsuccessful, to spur changes within those communities or legislative changes impacting those practices.
Another question?
Yep.
What do you mean by fighting negative stereotypes?
Well, the plaintiff lawyer stink. I mean, you're a plaintiff lawyer and you're trying to put this company out of business, cost all these people their jobs, and all you want to do is make a bunch of money. And as a matter of fact, all your clients are on disability, don't work, are pillheads, and they shouldn't even be allowed in this courtroom, you jerk. That's typically the, where we work in the West Virginia coal fields, you can figure any jury veneer, that's going to be the attitude of 30% of them. I mean, you're here to take their jobs.
And to get a free ride.
And to get a free ride.
So what do you do to fight that?
Try to be nice, try to be reasonable, try not to look like what I am, like as much as I can. Try, like I haven't been in court since July. Like I was in court for 10 straight weeks, with 2 trials, 3 days in between. So I kept my hair cut. I hadn't cut my hair since May. I haven't had like a major trial or hearing or anything, but yeah, I cut my hair. I'm nice. I'm really nice to the defense lawyers, even though I hate it. I try not to be mad in the courtroom and storm around, although you want to be. You just got to be nice and try to be reasonable, and try to and definitely don't ever say this mine needs to be shut down anywhere on anything that's ever recorded. If you're going to be in a jury in that county, don't ever say shut down and mine in the same sentence. If you're going to go before a jury of those people, if you're in federal court over in Charleston, you can do those. But if you're bringing a suit in Mingo County against a company in Mingo County, I mean, political correctness is and of course political correctness is kind of thrown on its head there. I mean, you got to make sure you are totally politically correct at all times when you're in front of that jury. Have your hair cut, shave, all the things I usually don't do in life.
Do you want to highlight any of the stuff on here?
You're good. Stop pollution. Oh, medical monitoring. We're going to talk about medical monitoring.
We'll talk about that one more later.
Injunctive relief, yeah. Money damages, yep. Property annoyance, punitives, and nuisance, yep. Okay. Typical mining impacts. Let's do this. Damage to structures. Man, I tell you, as a tort lawyer, this is a toughie. All right. I don't think you can win these anymore unless somebody has fallen in. Your blasting cases have been destroyed because there's a company called Saul's Seismograph, and they go out, and I don't trust the seismograph readings that they give. I've never been able to prove it in a courtroom, but all of the calculations that go into predicting damage are all overrun because they bring into court these seismograph reports, and it shows that no matter how big the blast was, there was no actual vibration at the home of your client.
Okay, so to step back, damage to structures, we're talking about damage to structures close to mountaintop removal sites,
Yeah.
where there's blasting occurring in the proximity of where people live constantly.
Those blasting cases used to be money in the bank, okay? It was something that you could count on and they'd settle. The seismographs have changed it, and now you can't win the case. I've lost them. I've lost a case in West Virginia. Well, actually, I got 50-50. Like, I actually won the verdict, but they said my people were 50% liable because they didn't keep their homes up, and I lost that one eventually. And then in Alabama, I lost a case, and both times I couldn't overcome the seismograph data. And
What, do they have a seismograph on the mine site, or what do they?
they got seismographs at people's homes, pretty much at every holler. They'll find somebody that'll let them will put a seismograph in.
And so why can't your clients do that?
Well, we probably could, but A, it's expensive. B, there's only one seismograph company really in the East anymore, Saul's. And then we get into a battle of seismographs. It probably adds a lot of expense. We don't know when the blasting is going to be, and usually we're there after the blasts happen. People come, like people's homes get hurt when the blasting's near their house. They got a couple of years in West Virginia to call us. Like, I'm never there when it's happening. I'm always there after it happens. And then they've got this historical data. And I try to say, on March 13th, there was this huge blast, okay? And I got all the records here. And here's all the calculations. I know how much ANFO you used on that blast, and my client said they saw a crack after that blast. That's generally how it works. Like there's a totally big blast, and it does a specific damage. Well, then they call me later. I'm here later. They've already moved on.
One thing in particular that's tough with the seismographs is it's somewhat standard for certain companies, like I guess Kevin was saying Saul's perhaps, that when they put the seismograph in, if they don't pack the soil tightly around the monitoring instruments, then it won't register the actual full extent of the vibration. And so they'll purposefully loose pack and then you'll get data that is more favorable to the industry. But it also, you know, it hasn't prevented you from.
It hasn't prevented me from
Other
suing.
things.
I mean, you know?
Okay.
Just because I'm gonna lose doesn't mean I'm not gonna sue.
Well, actually, we'll get it. We've got a separate slide for each of these, so.
Yeah, okay. Boom.
So just to go ahead and show like some of these typical mining impacts.
Dust, yeah. Burial of industrial waste, especially on backstacks. Oh, this is something you can look for on a mountaintop removal site. On a backstack, go back and forth down the face of it, and occasionally you'll find like a river of oil popping out. I found twice, actually 3 times. And that's what they've done is, so they don't get any violations for having a bunch of standing oil and grease and stuff on their refueling sites, they'll go and they'll scrape the refueling sites, which are huge, they're usually several acres, and they'll put all that in the dump truck and they'll go drop in the backstack, and they do it a few times and they lay in. Well, you know, they can put 100 tons of material in that soaking oil material in that backstack, and it pops out the side, and if you just go in the backstack, back and forth, back and forth, back and forth, then bam, you know, you might get lucky and find it looks like just like the clampets. I mean, you know, there's a little river of oil, and it smells like oil, and it's popping right out of the side of the mountain, you know, like a little stream. Those are winnable. Okay, those are something you can definitely win, and those aren't too expensive. Grave desecration and access, you know, I call that environment because you know, they infect, like they affect the environment, and there are some specific rules about how close you can come to a graveyard, and the blasting near a graveyard can decimate the graveyard, and they have to provide access to the graveyard. So you know, sometimes they make an island in the sky that you can't get to, and that's no good. You got to be able to get to your site. Finding clients.
Okay, so one issue for all tort attorneys is, you know, where do I find clients? You know, how do I actually have access to these people that have these problems that they could represent? So these are just a couple options in finding some of these folks, or how do they find you? I don't mention that as an option because my only experience is with Kevin, and he doesn't have business cards, he didn't have a public office front, he doesn't have a website, he's done absolutely nothing to market himself whatsoever. And yet he always has a few thousand different cases.
For years, our number was unlisted. We had an unlisted number. You know, I just didn't want people calling me.
That's one example of the kind of demand there is for attorneys to do this type of work. I mean, there are literally, like, every single person in some of the coal communities has good, strong claims, almost none of which will ever be litigated. And that's the way the industry gets away with their actions, because they know that there aren't attorneys doing this type of work. Okay, but so ways you can find clients. One thing that's worked exceptionally well for us is working close with grassroots environmental groups. So, you know, we worked a lot with OVEC over in West Virginia, groups like United Mountain Defense. The key is to work with groups that are grassroots, that are actually there on the ground. You know, if you're going to work with someone like environmental defense, they're probably not going to be putting you in touch with clients, you know, that have specific problems, that, you know, have their well drop out or have polluted water or something as often. Kevin already talked a little bit about the reputational considerations, and by that I mean it can be, it's a real question of when you work with those groups, if the same lawyer can be the one saying, I'm trying to stop this permit, and can also be the one that says, you know, this permit has caused all these damages, you know, now I'm going to seek relief for these people that have been hurt. And obviously there's a tension in wearing both those hats, just in some areas, and how you can be stigmatized. And if you're stigmatized as the outside environmentalist, it may make it impossible for you to recover good awards in juries where that industry is exceptionally important. But there are also ways to get around that. And we'll talk about a couple of those in a bit. Other attorneys.
Other lawyers. Car wreck lawyers, because people usually know a lawyer, okay? And it's either their deed lawyer, their trust lawyer, the car wreck lawyer, whatever. And hopefully you get, the car wreck lawyer brings you the case before he started working on it. what you don't want is the car wreck lawyer has now totally messed your case up. You're stuck in federal court, and you're just on your way to the Fourth Circuit to get your head bashed in because he didn't have a venue-giving defendant. It was complete diversity, and you end up in the Fourth Circuit and you lose your perfect fracking case. So but the car wreck lawyers, like the car wreck lawyers, the local guys, they often have these issues and they don't know what to do about them.
And there are also, and I'll throw out, there are also public interest firms out there that may come across great cases. People will bring them things that they may not have the time to litigate themselves, or maybe the expertise, or maybe the money to go ahead and finance those types of cases. So keeping close relations with those folks that are in public interest land is a way that folks can work together and see that some more folks actually see justice. This is something I like. Looking, our GIS expert from the other day is out now, but there's an amazing amount of public information, and this is something that we would do working with environmental groups also, and like your water testing.
Going through we just got a CD of 9 permits from the oil and gas office, and I still don't understand the Carter coordinate system, looking into it more, but on the permits where I actually found a summary that gave simple lat long, they are just completely off. And someone has since told me that it was actually like a vindictive person in TDEC who went back and fudged all of their GPS coordinates. So I'm having to go back and use our GPS tag photos to then take a Google Drive spreadsheet and plug it into Google Maps. But yeah, mapping is important.
Yeah.
That's a mess, and like mapping sometimes can be very easy. Folks that aren't, mapping specialists don't generally think, oh, you know what, I can go to the DEP site and get a list of all the Blackwater complaints, where folks have complained that their stream has turned black with some kind of pollution. And every one of those complaints will have a GPS coordinate attached to it, hopefully a correct one in some cases. And then I can map it in a matter of seconds. And I can see exactly where people are saying they have these types of problems. That's a good way you can assess issues.
Then ethically, we've never done this because we never try to get cases, but I thought that someone could do this, perhaps, okay? You can send out letters to zip codes if you don't know, like you can't send, like if I know that you've been hurt in a car wreck, I can't just send you a letter and say, hey, man, if you happen to have been hurt in a car wreck, give me a call, okay? But if I know that all of you guys live in an area where, there's a malfunctioning red light, there's a lot of car wrecks, okay, I might send that. And you could send a letter to everybody in the area. So one thing that we've thought about, but we've never done, I'm sure we won't, but somebody should get around to it. Like somebody should do this. If y'all have time, please someone do this. Do some mapping and then just send out, blank solicitation letters. I'm a lawyer, I do environmental law. Like if you've got a problem with your water, maybe give me a call. As long as you're not getting specific, yeah.
I'm curious, how much of a hurdle is it that in a lot of these coalfield communities, obviously people's property is worth next to nothing, and I assume you're not going after medical damages because of how complicated that is, but so how much of a hurdle is that when your clients basically, any property damage claims, it's not going to be worth very much? Is that do you only look for clients with property that's worth something, or how do you deal with that?
No, we take them all, and we do medical claims. I don't think, except for the blasting cases, we've never really done anything that didn't have medical. They're expensive and they're hard and they're horrible and it's awful, and everybody says you can't be one, but they can be. And the diminution of property claims. You can get even in Mingo County, in Rawl, we probably had an average property value of what, $50,000, $60,000?
Yeah.
$50,000, $60,000. And if they don't have water, then you can get an appraiser to say that's unmarketable. Not that it has no value, but it's unmarketable, which in appraiser world is slightly different calculation, because every property has a value. But if you're denied the full value or the reasonable value of your house because of something like there was a murder or a suicide in it, or it's the Amityville Hoarder, or it's got bad water, okay, then it's unmarketable, and the appraiser can say that it's unmarketable, they've been denied the value of their house, and it is X, and it's 100%. And there's USPAP is the policies, you know, the guidelines for appraisers, and it sets forth the areas. But we always, even with poor people, you know, we bring them in, you know, and we try to get that. You know, if you've got water in the community, most of the appraisers say that you still got a 10 to 20% loss. So, you know, a $50,000 house, that could be, you know, a $10,000 amount, and if you get your fees, then they can get that whole amount of money, and that's pretty good.
One thing that helps too is if you've got low value claims, if you can do a number of them together, so that the litigation costs are getting shared by more people. So you can just do it more efficiently that way.
And coal mines don't contaminate one well. They contaminate dozens or hundreds.
And then one other thing that is also an option when you do, and I want to point out that like doing something like checking the DEP site in West Virginia for all the Blackwater complaints, you can do that. You can put that information into a spreadsheet in about 15 minutes, and you can go online and create a map layer in about 5 more. Just like that. It's quite
You don't have
easy.
to be a GIS nerd.
No.
With
no,
Google,
I'm not, but
seriously, it's so easy.
yeah, I love making map layers though. It's like my favorite thing to do because I'm a big geek. And I was going to say the other thing you can do too, and it's something that OBIC would actually do sometimes, is they would call every single person in a community that made a similar type of complaint, where they noticed there was some kind of consistent problem, and they would invite all those people to some kind of forum where they could be advised of their rights and their process in terms of going forward. And that's another venue where they generally want an attorney to be present. You can provide some kind of general information and also meet folks and get an idea of what the issues are out there. And it's kind of fun too, like I remember one time where we mapped water complaints, and you know, like most of them appeared in communities where there was a lot of coal slurry injection that we knew about. But we found a whole bunch in this one area, and there was actually no mining there, and our layers of natural gas wells didn't line up with it, and we were like, well, what is it? And then we looked, and as we got closer and closer, we were like, oh, it's a wood treatment facility.
Right.
And you can always figure it out. It's not like things just happen randomly. There's always a cause.
But don't get the Blackwater complaints and then contact that person yourself as a lawyer, you know,
Yeah.
because at that point, you're now soliciting someone who's got a claim, live claim, and you know about it, and the defense lawyer will love that.
Oh, by this, I just meant live in some, if you can live in the communities where you're going to be doing your work and where the problems occur, you know, if something bad happens, I don't know how many days, you know, we'd get a call where somebody'd be like, there's a blowout, you know, and over, you know, this holler, you know, and so you're driving out there real quick with all your cameras and stuff, you know, to figure out what happened. Or the one day we woke up and we just saw like a huge plume of smoke in the distance, like from right behind Don Blankenship's house, you know, and so it's like hop in the car, you know.
Right.
So
That's just every day in Mingo County, you know, something blew up, oh well.
so yeah, just get out there and actually investigate things. Okay, flood cases.
Typical flooding. Trespass, because trespass comes from the sediment, okay? They got their sediment that comes down on your property. That's a trespass.
Flood cases, I think, are some of the easiest ones to explain in terms of how obvious it is. When, like this right here, this is Gilbert High School, and Gilbert High School was closed because of catastrophic flooding that happened from a fairly light rainfall shortly after this site was mined. And it just doesn't take a genius to understand how this happens. You know, in this case, not only is there the impact because the soil has been removed and the tree cover and all of the ecosystem's ability to handle water flow, but they've actually built a valley fill pointing straight down onto the school. So in this case, you actually have a funnel.
Right.
And this is, and the fact is, in most of these hollers, there are enough people scattered throughout, that they will build the funnel over top of someone. Someone is going to literally have a funnel right on top of them. It's very easy to show a jury the impact that the mining has had. The actual things that you've got to go ahead and show, that they'll argue about, peak runoff.
Peak runoff, you can't, pre-mining peak flow and post-mining peak flow have to be equal, or post-mining has to be lower, all right? Every permit you go to, they're equal or lower, because I don't know if you're aware of this or not, but actually, they will explain to you, they'll have engineers explain to you that taking all of those nasty, asymmetrical peaks off, and all of those silly trees, and get rid of those animals and that dirty grass, all right, and instead making a flat area where nothing's gonna flow off of, and then blasting it and cracking it, you've created fissures, and what you do is the top of the mountain becomes a holding tank for the water. So it's impossible for a mountaintop operation to contribute to flooding. And this is the argument that now I hear every time, okay? Some idiot from Virginia Tech has written articles about this now, okay? And says, no. These mountaintops have the capacity to hold billions of gallons of water, and this is much better than a native slope at preventing flooding.
But I've never heard of a jury that bought this argument.
Yeah.
Anyway.
Even Mingo County juries that are pro-coal are gonna just throw that away. Oh, and then framing in terms of jobs. You turn this on their head, okay? You got a mining engineer, okay? And maybe you got some other engineers, a civil engineer, like a hydrologist. Have them do all the calculations they can about moving dirt, how many men and man hours it takes to move dirt, how many men it takes to repair the piece of equipment. Because you know what? Doing it right takes more men and more equipment and more fuel than doing it wrong. And if you got to go back and redo it, that means jobs, because they don't have. And so on cross-examination, okay, I try to cross-examine the chief engineer for the outfit and get into the calculations and try to get him to explain how cutting corners saved money. So you flip the job thing on their head, because what it is, they love coal miners. They don't love coal companies, all right? The jury doesn't love coal companies, they love coal miners. So to be a successful tort lawyer, where you're suing the major employer in the county, you got to split the coal company and the coal miner apart.
And this argument resonates with juries because people in those communities, they remember all the union wars. They understand that the coal company has done everything they can to not hire people for as long as they can, and mistreated workers consistently. So framing things in terms of, this area over here, this could have actually been regraded and replanted already, and that would have helped minimize the impact. So maybe the school wouldn't have been closed, where my friend had his senior year of high school cut short for 3 months, because his school was flooded.
There's something that I don't like to talk about, and that is right across the creek from here are two mountaintop removal sites that were mined and reclaimed on a contract basis. Arch Coal owned the minerals, but these two wealthy gentlemen owned each of the mountaintops, and they had spent their career as dirt guys, moving dirt contractors. They said, we can do this ourselves. Sub this out. We'll take the reclamation. We'll take the responsibility. You pay us a few more cents a ton. Let us do it. On the site inspection, we ended up not suing those guys for this flood because it looked like heaven up there. They had actually segregated their topsoil, all of it. They had brought rock crushers in, and they'd gotten sludge from sewage treatment plants, and they brought in agronomists from WVU, and they'd added bacteria and all kinds of stuff, and they made themselves just an enormous amount of soil. They had properly sized ponds. They didn't rely on some calculation out of a book. They actually measured the slopes And they did it right. And today, there's like 500 head of cattle up on those sites. It's got thick grass, it's got dirt you walk across, it's not rocks you break your ankle on, and nobody, and on this flooding event, there were no floods. Like, nobody said they saw any unusual amount of water come off of those sites. They came off of this site and the one next to it.
So, I mean, you know, it's not a complete myth. We've seen the one actually reclaimed mountaintop removal site
Yeah.
in the world.
But in that sense, the guy who did it had some sort of economic reason to do it right. And the coal companies never have an economic reason. So I think that's why, I mean, we don't want to make a documentary about those sites, because if we do, the coal company will say, well, you see, mountaintop removal's fine. But you know, and those guys are pariahs in the coal industry. None of them have had any business since then, anything related to the coal industry. They are absolute pariahs. They make fun of them, you know, they were like, Clinton was called out at a West Virginia Coal Association meeting as a greeniac, yelled at, and left the meeting because he had reclaimed his mountain and then given an interview about it. And like, one of the fills actually has a hardwood forest growing on it now. I mean, it's crazy what these guys did. Yeah.
Who was that?
Clinton Darty from Mingo County. Just like, no company, just a man. And like, a man did the job right, you know?
Now, in terms of
and this is what it usually looks like.
yeah, this is a lot more standard.
Yeah.
Some of the other arguments that industry will make that these sites can actually, these slopes can handle more water post mining, is because they'll do things like build excess ponds, excess water ponds, and then they'll also have things like this. Like in this valley fill, the idea is that the water is supposed to go down these riprap channels. So where you may have gone ahead and filled in the natural creek, you created a natural pathway for the water to flow that's longer because of the path. But this is actually good evidence that shows that the water is coming straight down, because you can see the erosion gullies and that this is actually not working whatsoever. And this is standard.
Right, and that comes from the input numbers on the SWARA, okay? Because the stormwater runoff assessment, that's the formula that tells you how deep your ponds are, how big your channels are, how big your riprap is. So if you fudge the numbers at the very beginning of your calculations, you know, your pre-mining curve number, for example, you know, then that makes everything smaller. So what happens here? You got undersized channels that didn't take as much man hour to put in, and the water fills up, overflows, the channel busts out, the side of the ditch is gone, it goes right over, and it destroys your valley fill. And then, you know, 4 days later, an inspector comes out and says, fix that by next month sometime when I come back. And, you know, the damage is done.
And then sometimes on these flood cases, if you're ever litigating them, you'll notice that there's a common story where everybody will talk about how the water was rising and it was rising and it was coming up slow, and then all of a sudden the water level just went boom and it just shot up. That's common because that's the point at which the system got overloaded. The rivers, often because the rivers and creeks filled up. And that's often caused a lot of times because some sites that are poorly run they won't have lips to the edge, they won't have berms, and then they'll actually literally just push their spoil material over the side. And so this material will this debris will fill up those channels. So that's also good evidence to put out on those. And one last thing on flood cases is something that will always come up is you can always expect, well actually, yeah, something you can probably just guess. What is the defense always going to say in a flood case?
Act of God.
Exactly. You can count on that.
Yeah.
It would be an act of God if they didn't make that argument. And so they'll want to talk about the rainfall events. And the way rainfall events are judged is they're judged by a standard where how common was that much rain in that area. So they'll talk about a 20-year rainfall event or a 50-year rainfall event being the most extreme rain you would expect in a 20 or 50-year period. I used to actually worry on flood cases that you actually needed a tiny rainfall event to be able to resolve these cases. And I remember one time going out and checking out an area where a couple people actually died from flooding off of strip sites. And unlike this one where like the person that flooded in that picture last slide, that was from 2.2 inches of water, very little. That was a 2 to 5 year rainfall events, so happening fairly common. In this case, it was 7.5 inches of water that fell. That actually was sort of an act of God-ish, to their credit. And so I remember we actually didn't take that case. Another attorney that I later did some work for that was less scientifically minded, he did take that case. He still resolved all those cases. Because the fact is, and the mining engineers, guys like Jack Spadero will tell you that the peak runoff, he'll show you exactly how much worse the flooding was because of the impact of the mining. And if you do the right kind of watershed analysis, you can show that perhaps even if there was going to be some types of damage that you could expect because it was a large amount of water, that it was made that much worse.
Right.
And also these cases tend to be a little easier to resolve because companies have flood policies, They're used to having insurance policies.
Right, the insurance policies will pay off on a flood much quicker than they will on a groundwater contamination case because it's something the adjuster understands. It's a flood damage, it's something you can count up, and it's something you can see. Yeah, these are the experts you need, a mining engineer. That's important for the permit and the regulation, although they can't testify about issues of law. The environmental engineer, toxicologist. Toxicologist is key in any kind of a human health case. They establish general causation. You need two, actually. A PhD toxicologist who talks about general causation and does your research. Can this chemical hurt a human in this manner? And a medical toxicologist is a doctor who says, yes, absolutely, that exposure hurt that person in this way. The appraiser and then the economist, does medical monitoring, lost wages, all those things. Subsidence claims are, more and more pillaring and things like that come in. You can get SMACRA fees because it's a violation of the subsidence control plan. But most of your good information is not going to be in the subsidence control plan, but on its MSHA, its Mine Safety and Health Administration twin, the roof control plan. Nobody really pays any attention to the subsidence plan. Nobody ever writes any violations on it. But MSHA writes violations like you wouldn't believe on failure to follow the roof control plan. So then you get a violation of statute that's relevant to your damage, and you get per se negligence because of the mine health and safety violations, and they're usually much stricter than the environmental guys.
Well, and there can be, just to start, a misunderstanding from attorneys that don't do these types of suits often, because SMACRA stands for, it's the Surface Mining Control and Reclamation Act. So some folks will think, okay, this applies to mountaintop removal type damages. But SMACRA also applies to things like subsidence because it applies to surface impacts.
Right.
From underground mining also. So SMACRA, will work for most all those things.
Quicker. Angle of draw is their defense, okay? And it is, they always say, 30-degree angle of draw between the end of the mine and the structure, okay? If you're within this 30-degree angle of draw, you got subsidence. If you're outside it, you don't. But that's a defense that fails. There's plenty of mine industry publications and studies that say that you can have damage up to 51% and beyond. Let's move. Okay, grave desecration. Let's just, we don't need to show the video. We're running out of time. They clapped over there. Okay, grave desecration. There was no tort of grave desecration until this case in West Virginia. If a grave got desecrated, it was either a statutory violation of some law, like gas law. Well, I guess gas doesn't really have, like most states don't have a gas buffer, but SMACRA has a buffer. And it determined that the descendant of the person who was dead had a quasi-property right in their grave. So all the way back, we trace cases back to 1600, and that's the basis of recovering for a grave desecration. The West Virginia Supreme Court said that's silly. All right, and what they did is they've established a tort of grave desecration. If you have an identifiable cemetery and it was desecrated, and you have a survivor on some per stirpes level, like all the daughters or all the children, grandchildren, you know, each level, like if you got two sons and one dies and he has two sons, this son up here who survived, he gets all the money, and these grandsons get none. The Supreme Court also said they had punitive damages were available, that you could find emotional distress, nuisance, trespass, property damage. And that case has been followed in Texas and North Carolina since then. So I think, and grave desecration, I didn't have any idea that it was so widespread. But I mean, since I've had this case and it was published, I mean, probably 10 different people around the country have called me with grave desecration cases.
Didn't OSM in the last few years actually make the buffer zone a lot smaller from graves?
I don't know, it's 100 feet now. So it was probably 300 feet before, you know.
Yeah, I wonder how they got away with doing that.
Yeah, I wonder how they get away with a lot. Okay. Damages, blasting. Blasting cases are tough.
Well, you said
Yeah.
you're negative on blasting cases.
Yeah.
I remember there was all about 70 blasting cases while I was there, and that we got a jury verdict in our favor. But let's see.
7/10 of a mile from the permit.
This is nice. These are strict liability for an inherently dangerous enterprise and blowing up mountains.
Right.
So you've got a rebuttable presumption, you know, that you're dealing with, that hey, this damage is gonna be attributed to the coal company if you've got people within 7/10 of a mile of the blasting or of the permit. They can also be within a half mile of the actual blasting if for some reason you couldn't quite show the 7/10. The other requirement is everyone within 7/10 of a mile will be given the option of a pre-blast survey under SMACRA, and that's a survey where someone will come to their home and take pictures of the home that act as the before shots, so that if they have damages later, they can have the after shots and show the difference. If somebody ever asks, you know, should I let them, you know, come into my home and take pictures? The answer is yes. Those pre-blast surveys are very helpful. And denying one is going to be negative if you end up, it's going to be used against you if you don't have one.
Carrier street, okay, I tell you what you look for. At windows, you're looking for a diagonal cracks going out at a 45-degree angle from the corner of a window, because your thresholds, the holes in the wall, are the weakest points, and that's where the blast is going to have its first effect. So if you don't have these 45-degree angle cracks from the thresholds, doesn't necessarily mean you have some damage. Subsidence damage goes like this. So you have like a crack in the foundation. You don't typically have, or you don't always need to have a foundation crack to have blast damages, because the energy comes into the foundation and then dissipates to the top of the house. So also, the crack should be wider at the base and narrower at the top, like earthquake damage. In fact, it's exactly like earthquake damage. It's exactly like the same way a structural engineer evaluates earthquake damage. That's the same rules of thumb they apply with blasting.
And in terms of chaining, for folks that aren't familiar with like how the actual blasting occurs on these sites, these are all like separate core holes that are drilled out and then filled with AMFO, ammonium nitrate and fuel oil. It's basically going to be fertilizer and diesel. And they're set, and then there's some kind of capper on top, which allows them to not all explode at once. That's why they have these separate core holes. Because if they did explode all at once, then you would have a huge seismic wave that would cause all sorts of damage to people in the community consistently. So they're delayed by microseconds, so that instead of getting one giant wave, you get a bunch of little tiny waves. That's the idea. Now what you'll find though, is that sometimes there's an error. And when there's an error, what'll happen is called chaining. And that's where everything blows up all at once. When chaining happens, that's when everyone's like, oh my gosh, did you hear that? They get a lot of damages. That's where if folks in the community know to keep blast calendars, that's where you want to be able to show that a lot of folks noted that there was a really heavy blast at the same time on the same day. Because then, regardless of what the coal company's record says, you know, it may indicate that chaining occurred then, and actually created a much larger seismic wave than you normally expect based on the equations in a blasting case.
Dust. Private and public nuisance claims. Public nuisance gives mental distress in West Virginia. What's next? Diminution of property value. That's actually, they, like a lawsuit by a friend of mine that's in Sylvester resulted in putting that dome over that coal pile.
It's a nice example of injunctive relief.
Yeah, that's a perfect example of injunctive relief from a tort suit, okay? Okay, gathering the evidence. This is like, yeah, this is a great way for people to gather evidence of this is they wipe off the front of their house with a white paper towel, take a Sharpie, write on the white paper towel the date, put it in, then take pictures of themselves washing their house off, okay? And they go back like a week later and they do it again, and it's the same thing. Put the piece of paper, like put the paper towel in the baggie, zip it, and write the number. It's the Dust Busters from the National Geographic, like a group of elderly women that lived there. They're the ones who actually came up with that, and it was the case-winning evidence.
And can I
Water
just ask
contamination.
on the dust, have you ever gone after coal trucks or?
I've never gone after coal trucks, but coal trucks were a part of that case. Yeah, but they have a lot of dust too, and you can do the same thing.
Would you do it if you had a good case?
Yeah, I'd do it. Yeah, I think a coal truck would be an easy case. Yeah, because people in coal communities hate coal trucks. So I think like that'd be a good one. This is raw. This is what happens when you have slurry injection. I think that slurry injection is the absolute worst thing that the coal companies can do.
Do you want to say what slurry is real quick?
Slurry is the water that carries the fine refuse, the little tiny bits that they get out of the prep plant, and is what is stored in those giant slurry impoundments. This was from Raw. There's been 2 cases about this. Both have been wildly successful. We had one, and some other guys in Charleston did the other one. And I mean, this is just horrible. And these people are poor, and these people were looked down upon by everyone in the community anyway, because in a poor county you always want to look down on the poorest person you can find because it makes you feel better about yourself. And nobody cared. And over 1 billion gallons of slurry was injected into underground mines that were closer than 100 feet to these people's wells. This was Kenny Stroud. Tiffany Price, I know her. She's about 20 now.
This is not like a picture that was taken to show evidence. This was just a baby pic. Because the reality in this community was, maybe they could hope for better times as far as drinking water, because the water quality varies throughout the day. When it came to baths and stuff, folks were pretty much just limited to using what they got out of their wells. And the health impacts from all the ground up heavy metals that were in the slurry and injected in huge quantities. I mean, 1 million gallons a day of the slurry would be injected into the water table in this tiny community that people drew their well water from, and just incredible health impacts.
Now the SCMRA, or the permits, are going to have groundwater inventories, okay? The groundwater inventories are generally determined by the contractors hired by the coal company, okay? And they're the ones who come in and fill it out. And a lot of times they'll say, well, has your water ever been red? Yeah, a lot of people have iron water, okay? So what the coal company then says, and what they said in this case was, they had a groundwater inventory that said red water. They said, these people already have red water. Well, there's a big difference between a little iron water and this. And they'll use those groundwater, and in this case, they use the groundwater inventory to say, look, this water has been like this for years. And they're like, no, okay? We had some red water occasionally, once a month, maybe it would run like a little orange tint. Nothing, this is tomato soup, and the worst is when it was black.
And this is a good example of also some other forms of injunctive relief. But in this case, an injunction was one for temporary water supplies for these people way before there was a trial resolution. And then through organizing that was happening in the community, these folks also got public water lines run to their home. So this is a good example of, even if we had lost this case, these folks still have water now.
And next week, WVU Medical School will have its mobile lab down there, and we start our medical monitoring program next week in Raw. And that'll go on for 30 years.
Those pictures ought to be great. Pictures for why you don't want to frack.
Right. I mean, you know, that should say why you don't want to do anything to the groundwater.
That's right.
That's good, thanks.
And then even more common, I'll just say, even
Yeah.
more common than slurry contamination from underground injection, acid mine drainage. Pretty much wherever you have surface mining, you're going to have potential impact for acid mine drainage, which can cause horrific water problems also.
And pillaring and long wall operations create fracturing, and that mining-induced heavy fracturing changes the geochemistry, which then essentially results in not something that's coming out of outfall, but acid mine drainage doesn't drain, and instead goes into people's wells. Medical monitoring is available in only a few states, but it is to get a diagnostic program together. Next, where is it available? I don't know. West Virginia, New Jersey. Would a medical testing regime provide real significant benefit to the impacted class? You're going to have a fight on this because people will realize that, oh, wait a minute, all you do is you're diagnosing me, you're not treating me.
Okay, yeah, so to say like, just a few more words on what it is, the idea is in some states, the idea of injury has been expanded so that somebody actually has an injury just because even if they aren't showing signs of a disease caused by some kind of contamination, but just because they've been put in a higher risk category. Now, the only relief available for that type of injury that is sort of a shadow injury at that point is that in some states, you can seek medical testing to be paid for by the company that increase the chance that that person would have those diseases if there are specific tests available and if they would have a significant beneficial impact on those folks.
So this is the only medical tort in environmental law I'm aware of that you don't need a medical toxicologist and a specific finding, a specific causation. The test, the scientific burden of proof here is general causation, because you're not saying you were hurt, you're saying all of you were exposed to something that could hurt you in the future. And it makes it a less difficult hill to climb.
And then I put this last point on here because in the case that I worked on where we won a medical monitoring program, in Raw and slurry case, we could show that testing would very genuinely save a number of people's lives, if it was implemented. In the Tort case, where we attempted to make medical monitoring claims for children, put at higher risk for asthma and some other respiratory problems, it just was not near as convincing to the jury, I think, in the end, that the testing would really be of that much benefit. And if the jury doesn't believe that testing is going to help, they're not going to make the company pay for it.
Right, exactly. Contingent representation. Yeah, I mean, these are just basic thoughts that people don't understand, okay? I mean, people have car wreck cases and they understand, this is the same contract operation as a car wreck, but people don't, I think because of the size of it, they just think they gotta pay. I mean, you need to front the expenses for the person, okay? And then the fees come from recovered funds. You have to come out with, explain that there's a statutory fee that can act as a discount against a contingency fee. And then, in the contract, put in there that they gotta help you. Because the problem is you get a community, and a community has all sorts of people. And it really helps if you can point to the contract and say, you said you were going to come to the depositions. And I actually have now in it, I, the client, agree that I will attend the like I got bullet points, attend the deposition, I actually have answered the telephone when we call, like about 8 things, because it is the biggest, when you represent a community, your biggest problem becomes the community. 10% of that community takes 30% of your effort because they don't answer the phone, they don't tell you when they move, and it just becomes impossible. And it's critical to get that in, because if you can't get that, and sometimes you got to point it to them and say, "Why not? You're my lawyer. You do it." I can't give you deposition.
Nothing better than the class rep.
Right.
Get in touch with.
Right. And then resolving mass problems. Okay. Oh my gosh.
Oh yeah, I was gonna say we could go off on this for a while.
Yeah.
But because we're running out of time, And let me just note that when you've got mass litigation torts that you're working on, where you have a number of plaintiffs, you run into some specific problems because of that. One of those things is if a case is like, when cases settle, when do they tend to settle? Right before trial, exactly. And what's one of the biggest carrots at that point that you're essentially waving to the defendant to go ahead and settle the case? That they could avoid the cost of trial.
Peace in the valley. They want peace in the valley.
This becomes a problem when, say you have 20 blasting claims for 20 different people. Do you need to get all 20 individuals to go ahead and settle to make this disappear for the defendant? Generally, yes. You know, if you settled out 19 and have one, that one person's still going to have a trial. You're going to have all the costs of all the experts that have to be there. They're going to have all the costs. They're going to have to be there. It's not good for, it's not ideal for anybody. And one option for getting around this
Well, and there's another one. Let's say you come to a tentative agreement on a lump sum settlement and somebody's at the end of the alphabet and you've now gotten 80% of your people signed up and somebody's name starts with T and they figure out, wait a minute, looks to me like my claim's worth $1 million because you need my signature to make this deal go. And, you know, you get a key together, as much as you love them, you know, you're going to have these people that raise their heads and try to get their own benefits. So, the lump sum settlement agreements.
This was this was something I discovered from another attorney that I worked for that had an easier time resolving some of these types of cases. And I was like, how do you do it? And it's the most amazing thing ever. You deal with the problem before you ever get to settlement. And so what you would do in this kind of setting is, and I included in the CLE materials, everyone's got a copy of one of these if they want to look at it. But you go ahead and you get the community to agree initially. Like you explain why it's to their benefit to both the defendant and to them to settle all the claims collectively. You have to do this after discovery. But after discovery, when you've got an idea of everybody's damages, at that point, you make sure it's okay with everyone in the community, but you get them to all see what each other's number is in terms of damages, and that will end up being their percent of any settlement that's achieved. And you get them to agree to vote on some bargaining rep to make the eventual decision for the whole community. You do that beforehand, and it can really make settlement happen in a lot of cases where it wouldn't otherwise. And, oh cool, give me the last slide.
Well, media is good, litigation, yeah. Oh yeah, a lot of times we get all our clients to go to the Capitol and you know, lobby for some legislative change, and then sharing your science and data with everybody you can, and not entering into any settlement agreements that lock up your data. Because hey, Andre, because you want to get your data out and you want to share your data with all the scientists you possibly can, and that's critically important.
Yeah, and one thing is, if you're anticipating a settlement, you know, make sure that if there are environmental groups that could use that data, like in the Marshport case, we lost that litigation, but we were able to do, through the litigation, a couple $100,000 worth of science that wouldn't have otherwise been done. And that science was helpful for the people organizing to just try to get a new school. So, you know, making sure that they had that information.
And they got a new school.
And they did get a new school.
And they got a new school. So there you go. You know, we lost a bunch of money, and we had a huge ego chunk when we lost the trial. But, you know, in the end of the day, oh well, the kids got a new school, and we won.
So just, you know, make sure that they have that information before it gets locked up, after something's happened. You know, just to say, lobby days are also great ways to give clients practice in terms of telling
And one
their
more
story.
thing, these are expensive, but there's always lawyers out there with money who will invest in your case. You know, I'm poor, but I've never had a problem bringing a case because I've always found rich guys that will pay the bills for me. Because if you hit one of these, it's a big payoff, and that's what the big tort guys are in it for. So you know, there's always a plaintiff's lawyer with a jet somewhere.
There's a market for that. There's a market for that.
There's a market, yeah.
That's right.
Yeah.
A formal market.
Yep, there's an informal market that you can do. All right.
And I was going to say, just, if, you know, finally, we want other people to take on these types of cases, to hold industry responsible. You know, both of us want to do everything we can to help attorneys that are interested in doing this type of litigation be successful. So please, please contact us if we can be of any help. For myself, since I'm still a law school student, please contact me if I can be of any help over the summer. You know, I'm looking at coming back to this region. I've got different reasons I want to be back in the Southeast.
So you are in two different places.
Yeah, he's out at law school in Portland, and I practice in Charleston.
But yeah, if there are any attorneys that have interesting tort cases or that are looking to bring some of those into the mix of what they're doing, you know, please get in touch with us if we can be of any use whatsoever.
Thank you very much.